A Justice Ashok Bhushan-led bench of the Supreme Court today heard the petitions seeking criminal contempt charges against comedian Kunal Kamra and comic artist Rachita Taneja. Rachita Taneja, through her lawyer, senior advocate Mukul Rohatgi, informed the court that she has not filed an affidavit in the Supreme Court and that there was no reason to proceed against any case with Taneja here because she was a young 25-year-old girl who had made certain, comic impressions. And Senior Advocate Rohatgi told the bench that the foundations of the Supreme Court is not so weak that it would stand shaken by the comic portrayals by Rachita Taneja. To which Justice Ashok Bhushan said that he agrees with the senior lawyer, but such posts and commentary about the court is being done everywhere. Justice M.R. Shah intervened that it would be better for Senior Advocate Rohatgi to file an affidavit in this case. Otherwise, the court would proceed against her. Noting all these submissions, Senior Advocate Rohatgi has now told the bench that he would be filing an affidavit shortly in the Rachita Taneja case. Now, moving on to Kunal Kamra's case, comedian Kunal Kamra was represented by Advocate Prithaash Kumar Iyer. Kamra had filed his affidavit today morning in the Supreme Court in reply to the notice issued by the Supreme Court 6 weeks ago. Kunal Kamra has refused to apologize to the Supreme Court of India for his tweets, which allegedly bring disrepute to the judiciary. A bunch of petitions sought criminal contempt of court charges against Kunal Kamra. Kunal Kamra, in his affidavit, has said that to believe that any institution of a democracy is beyond criticism would be to believe that the migrants who were walking during the pandemic were doing that out of their own free will, which was entirely irrational and undemocratic. Kamra even went on to highlight the Munawar Farooqi case in his affidavit to showcase how freedom of speech and expression was endangered in the country, and that it is time that the Supreme Court proves that the freedom of speech and expression is a cardinal constitutional principle. Kunal Kamra, in his 6-page affidavit, has also made it clear that he in by no way tried to bring any disrepute to the judiciary or to the majesty of the court, and that his tweets in no way could be held to be contemptuous. Well, moving forward, Justice A.M. Khanwilkar-led bench today asked the Union of India if at all it could consider as a final chance to the students who had exhausted their last attempts in the UPSC prelims of October 2020. Justice A.M. Khanwilkar even went on to observe that it was not the first time that the government would be giving an extra chance or an extra attempt to the students suffering due to the COVID-19 pandemic. Well, the Chief Justice of India, S.A. Bobde-led bench today granted permission to fell about 4,108 trees by the Rail Vikas Nigam for the third railway track in the Taj Trapezium Zone area. The CJI noted that such felling of trees would be subjected to the conditions laid down by the Central Empowered Committee. Well, lastly, the Chief Justice of India, S.A. Bobde-led bench today issued a notice on a petition by BJP leader Ashwini Kumar Upadhyay seeking uniform grounds of adoption and guardianship. Upadhyay had earlier filed 2 petitions seeking uniform grounds of divorce, alimony, and maintenance, irrespective of sex, caste, creed, and religion in India. And those 2 petitions, the court had also issued notice to the central government. On today's petition of adoption and guardianship, also the court issued notice and asked the Union of India to reply to it and has tagged it with the similar pending petitions. Well, as a Chief Justice of India, S.A. Bobde-led bench was today hearing a case where an accused was seeking bail from the top court. The advocate of the accused sought bail on medical grounds and said that the accused was suffering from kidney failure. To this, the Supreme Court, led by CJI S.A. Bobde, said that if death is imminent, then bail would make no difference, and that people are dying every day and the court can do nothing about it. The court also went on to say that if the person has to die, he can die even outside jail when he's on bail. However, to this, the advocate said that there was certain medical necessity and that at least medical facilities should be provided to the accused. to which the Supreme Court has agreed and has directed that all medical facilities like dialysis, etc., is provided to the accused within the jail premises. And now this bail application will be heard during the summer vacations. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court today on Monday as well. And don't forget to like and share baronbench.com.